Hello, Michael Strickland back here again with another one of these first-person videos. For those of you who are unfamiliar with me and in my case, I was the video news journalist who was out filming a protest on the evening of July 7th, 2016, when I was targeted and attacked by a mob of masked thugs, and I acted in self-defense to prevent them from beating and robbing me, except I was the one arrested, charged with crimes, and eventually found guilty of 21 counts when the violent thugs who started the fight are considered to be the innocent victims. So I'm now doing this first-person video series here as I continue to fight my case through the appeals process, and I just feel it's important to bring up numerous things that have transpired around the case. And in today's video, I'm going to talk about how this ruling, and specifically Officer Ryan Rasmussen's testimony, puts law enforcement officers at further risk across the state of Oregon. So I'll start with the obvious here, and that is that it's been adjudicated that it's legal for a mob of masked thugs to attack someone in the street, be it journalists, politicians, judges, district attorneys, activists, law enforcement officers, and you cannot legally defend yourself against them. Now, one of the interesting things that happened during the trial was that the district attorneys and some of the police officers involved were trying to vaguely state the case that 40 seconds after an incident is considered to be a separate incident, whereas I viewed it to be a continuation of the same incident. You see, when I was initially surrounded and physically roughed up by Benjamin Carenza, he was the guy who led the mob. He's literally twice my size, and he has a very lengthy criminal history. So he surrounded me, started pushing, shoving me with a bunch of other guys with masks over their faces. So I started retreating immediately. And I eventually pulled my firearm about 40 seconds after that initial attack. As I was retreating and as these people continued to encroach on me from multiple different angles here, my attention was drawn to my right, and Carenza was now coming up on my blind side. And that was the moment that I drew. You know, I had exhausted every other practical option at that point. So the DAs were making the case that what happened when I drew the gun is a separate incident and not relevant to when Carenza and these other guys, just 40 seconds earlier, had physically roughed me up. Now, the way that would apply to law enforcement would be if a law enforcement officer contacts someone who they know is dangerous. Let's say they got into a fight with a particular subject a month prior, 6 months prior, whatever. They're saying that that previous incident here would no longer be relevant to an officer's actions in dealing with that subject now, which I find to be very interesting. I would think that that would be very relevant if an officer has prior knowledge or a citizen has prior knowledge of someone's violent tendencies. That would absolutely alter the way that they should handle a situation. So they're basically making the case that personal experiences are not relevant. For example, about 16 months before the incident in question, I had 2 video cameras stolen from me, and I was body slammed onto the pavement and my arm broken in multiple spots requiring multiple surgeries. Now the judge ruled that to be inadmissible. They're saying that experience does not weigh in someone's mindset to use a firearm to defend themselves in a separate incident that's now occurring 16 months later. So if an officer has a particular experience in a particular situation, they're basically saying that that particular experience does not weigh on an officer's mindset when he's dealing with subjects and situations in the future, which I find to be a little odd. I would think that those experiences would weigh into an officer's mind. So those of you who have been following the case are aware that the prosecutors brought forth an ambush witness on me, and the judge allowed it. That was after the state had rested and after my defense had rested. Then the prosecutors decided to bring forth an ambush witness, their own expert witness now. Of course, we contested that during the trial, and it's one of the things that we continue to contest in the appeal because the prosecutors had plenty of opportunity to bring forth an expert witness during their what's called the case in chief, their main portion of the trial. So this was Officer Ryan Rasmussen. He serves as the use of force and firearms trainer for the Gresham Police Department. Now, he was not a witness to the incident in question, but he served as an expert witness in the field of firearms and use of force. What's interesting, though, is that his testimony only applies to how police officers are trained and how police officers would react to the situation that I found myself in. Rasmussen has no certifications to train civilians. He has very little experience in the civilian world because he basically went straight from the Marines into law enforcement. The only time that Rasmussen has drawn his firearm and discharged rounds was when he shot a dog from 20 to 30 yards away. Now, he claims that he had prior knowledge of this dog. He referred to it as a very vicious golden retriever. So I find it interesting, though, that somehow he's justified in the prior knowledge that he had of this dog, but I wasn't somehow justified with my prior knowledge of Benjamin Carenza's violent tendencies. So they're also making the case here that what Carenza had done to me 40 seconds before I pulled the firearm is not relevant, but it's relevant to Rasmussen when he pulled the firearm and shot at a dog. One of the other interesting things as it relates to that is Rasmussen claims that they no longer go by the 21-foot rule. Those of you who have training in firearms are aware of the 21-foot rule. So he says they no longer go by that. But he felt justified in engaging a dog and discharging rounds at a dog from 20 to 30 yards away? That's justified? But me pulling a firearm and not shooting is not justified? Much of my appeal centers around the statements that I had made to the detectives, which were said about 30 minutes to 4 hours after the incident. Now, these are the detectives that had me in custody that night after I was arrested. Now, the prosecutors and even the appeals court judges are trying to say that this was a historical account of what had happened and were somehow not relevant to my mindset during the actual attack on me, during the actual incident in question. And thus they're saying that those are inadmissible because the judge ruled that those statements are inadmissible, could not be admitted into court. So I find that interesting, again, because police agencies, particularly the Portland Police Bureau, and from what I gather several other agencies in the state of Oregon, have what's known as the 48-hour rule, whereas they are not to be interviewed by investigators until 48 hours after an officer is involved in an incident, whether it's shooting someone or whatever. So by applying the same standard in my case to those police officers, if they're saying that what I said 30 minutes after the incident isn't admissible, then certainly what a police officer would say after an incident 48 hours after an incident would be even less relevant, even more inadmissible. So a police officer's statements 48 hours after the fact would be moot. So in my previous video, I went over the case law as ruled by the Oregon Supreme Court that gives someone the right to fight police if they reasonably believe that an officer is using beyond the minimal amount of force to bring someone into custody. Now, one very interesting thing here, probably the most interesting, is that Rasmussen testified that officers are not trained to draw a firearm and not shoot at a subject. Now, Rasmussen and the Deputy District Attorneys Todd Jackson and Kate Molina were vaguely trying to claim that if someone draws, then they need to shoot. They were vaguely trying to say that if I were actually in fear, then I would have fired. Now, I was taught to shoot until a threat has been neutralized. In my case, the act of me drawing the firearm, pointing it at what I believe to be hostile subjects who were using unlawful force against me and were about to use further unlawful force against me, was enough to neutralize those threats. They all stopped and or got back at that point. Thus, the threat was no longer there, and I reholstered. I didn't need to fire a round. So, they're claiming that police officers are not trained to draw and not shoot. So if a police officer is doing that, then that would constitute unlawful use of a weapon on the part of the officer, just as I was charged with and ultimately convicted of. Furthermore, as ruled in the State v. Oliphant and Wood case in my previous video, if the person whom the police officer is drawing on and not shooting, then that's an unlawful use of a weapon. That's not the way an officer is trained to deal with the situation, the officer is not following their training, then that person, as per the Kenneth Wood and Oliphant case, has the legal right to defend themselves against what is now established as unlawful force being used against them by the officer. A bystander can also do this. They can also defend that person from the police officer. Now, what I'm saying here isn't necessarily my personal opinions. I'm just telling you what the judges have ruled, what the police have testified to, and what the DAs have argued for. So, the scary part here is that if a police officer is doing that, if they're drawing, not firing, that's apparently they're not trained to handle a situation like that, and that has been adjudicated to be beyond the minimal amount of force now. The person is allowed to defend themselves against that. The scary part is there's really only one level higher than drawing a gun and pointing it at someone. And if you're defending yourself or another person, you need to go one step higher than the force being used. And that is, in a roundabout way, you could argue that it's legal to shoot a police officer if they're drawing on a subject and not firing. That should strike fear into every law enforcement officer in the state. Now, I personally have witnessed Portland police officers drawing their firearms, pointing it at a subject. If I recall, this person had a knife. It was dark. They did not shoot at the subject because the subject followed their commands. He dropped the knife. Just like in my situation. I issued commands. The people followed my commands. I didn't have to shoot. Just like those police officers, I reholstered. Those police officers reholstered, and they did not have to shoot. But according to Ryan Rasmussen, that's not the way police officers are trained to handle things. Now, I believe that Officer Rasmussen shows poor judgment. He has a history of this. There was one particular instance, in fact it was in the news, where Ryan Rasmussen would rather get beaten by a gang than defend himself. He was standing on a MAX platform. Now, MAX is the light rail train system here in the Portland area. And he was attacked by a gang of thugs. Rather than defend himself, he let them beat him. So not only does that show bad judgment on his part, but it's also turning into a legal standard. Just like what had happened in my case. Now, from what I hear through the rumor mill, Ryan Rasmussen's testimony is already being used by civil attorneys to sue police agencies, cities, counties, and individual officers in Oregon, particularly in the Jason Washington case and the, is it Michael Graves or Matthew Graves? Because Rasmussen's testimony during my trial goes into some detail as to what officers are trained to do and not to do. So now those attorneys are using Rasmussen's own statements against police officers. Essentially, Rasmussen has made it easier for citizens to sue police departments. Now, as more people sue these agencies, the city and county leaders, I could totally foresee cracking down and telling their police chiefs and sheriffs that their officers and deputies need to use greater discipline when using force. They need to wait longer before drawing a firearm, pointing it at a subject, or firing at a subject. And that standard has now been raised higher by Ryan Rasmussen. And this is even against a subject whom the police officers have personal knowledge of being dangerous, because the judges ruled that that's not relevant. So, as these officers are being told to show greater discipline, that opens up more of a window for the officers to be attacked by violent subjects, assaulted, or even worse, assaulted, injured, maybe even killed by subjects. And it's all thanks to Judge Thomas Ryan's ruling, prosecutors Kate Molina and Todd Jackson and the arguments that they made, as well as Officer Ryan Rasmussen's testimony during my trial. Now again, these aren't my words. These aren't my judgments. These aren't the things that I was arguing for. I wasn't the one who brought Rasmussen up to testify as an expert witness after both sides had rested. That was Kate Molina and Todd Jackson. I wasn't the one who allowed his testimony, and that was Judge Thomas Ryan. I'm not the one who established this astronomically high standard for when it's appropriate on certain ways of use of force for police officers. It's Ryan Rasmussen who has. I'm merely the messenger. And this is why every law enforcement officer in the state should be supporting me in my appeal on this. Because if we can get the case overturned, then Ryan Rasmussen's testimony is thereby discredited, and the officers aren't put at such risk anymore. Thank you for watching, and again, if you're new to the channel, I encourage you to look at some of my other videos. I've done a few other of these first-person videos where I go in-depth as to some of the odd things that have happened. I take a lot of the audio from the trial and some of the statements made to the detectives by some of these people, some of the things said by the district attorneys, and I also do a heavy video analysis of the actual incident in question. So thank you for watching, and we'll see you next time.